So we'll get started. Welcome everyone to our evidence-based practices in crisis care webinar session. We're very excited to have you today. I'm Megan McGregor, and I'll be bringing you through the start of this session. I just want to take a moment to ensure that everyone in the audience is ready and comfortable with the technical aspects of this webinar. As you'll see, closed captioning is enabled for today's webinar. We also have American Sign Language capabilities enabled in this meeting. You can activate that by clicking the interpretation icon on your Zoom navigation bar. If you need tech support during today's webinar, please send a chat message to the host and we'll address that as quickly as we can. And finally, if you have questions during the presentation, please enter them into the Q&A area. The questions will be sent directly to the presenters and moderators, and we'll do our best to answer those as quickly as possible. And those that we can't answer, we will save for our presenter at the end of the session. Next slide, please. I'd like to note that the views expressed in written conference materials or publications and by speakers and moderators do not necessarily reflect the official policies of the U.S. Department of Health and Human Services and SAMHSA, nor does the mention of trade names, commercial practices, or organizations imply endorsements by the U.S. government. Next slide. Today's webinar is hosted by SAMHSA's 988 Crisis Systems Response TTAC. SAMHSA has selected Altarum to provide training and technical assistance support to states, territories, tribal organizations, and community partners across the 988 Suicide and Crisis Lifeline and Crisis Continuum of Care. Along with our partners, W2 Consulting Corporation and Change Matrix LLC, both of whom have extensive experience with crisis services and technical assistance, the CSR-TTAC was formed to support the continued growth of the 988 Lifeline and build a more robust crisis care system. The goals of the Crisis System Response TTAC is to support a crisis care system that's integrated, sustainable, and aligned with evidence-based and evidence-informed practices. We'll be dropping in the chat a link to that TTAC for you to learn more. Next slide, please. Oh, already there. We'd like to welcome our SAMHSA team. Ms. Jill Mays is with us today. She's the Division Director of Crisis Systems Transformation for the 988 and Behavioral Health Crisis Coordinating Office. Hi, Jill.
Hi, Megan. Thanks. Good afternoon, everyone, and welcome to today's webinar. Today's session focuses on something that's at the core of high-quality crisis care, and that's making sound, principled decisions in moments where the stakes are high and the path forward isn't always clear. Raise your hands if you're working in crisis care and it's not always clear what the right next step is. Well, ethics, it isn't, we shouldn't consider it as something separate from care delivery. It's what really can help define that quality in crisis care. The way we navigate autonomy, safety, fairness, and transparency, those are things that can directly shape outcomes, trust, and most of all, the experiences of those we serve. So whether you're supporting someone on the 988 crisis lines, responding in the field, or working within a stabilization facility, these situations demand both clinical judgment and ethical clarity. This session builds on the ethical principles outlined in SAMHSA's 2025 National Guidelines for Behavioral Health Coordinated System of Crisis Care. That's a mouthful, right? Reinforcing how concepts like autonomy, beneficence, non-maleficence, justice, fidelity, and veracity all guide our real-world decision-making across the crisis continuum. So today we'll explore how to apply these principles in practice with particular attention to trauma-informed and recovery-oriented approaches that protect the dignity of those we serve while meeting our safety and legal obligations. So I'd like to extend a sincere thank you to the CSR-TTAC team for coordinating today's event and to our presenter, Dr. Frederick Reamer. Dr. Reamer's teaching and research focus on professional ethics, criminal justice, mental health, healthcare, and public policy, and we're definitely fortunate to have his expertise guiding us through today's discussion. So again, thank you for the work that you do every day and for taking time to deepen your practice with us today. So let's get started.
Thank you so much, Jill. Next slide. We also want to recognize Dr. Laura House, who's the External Engagement and Capacity Building Lead for the 988 and Behavioral Health Crisis Coordinating Office. Next slide. And the 988 TTAC work stream, we have Bree Carr, Jennifer Sedovey, and myself. Also want to recognize our comms team who is doing all the behind the scenes work to make this possible. We really appreciate you guys. Next slide. All right, our learning objectives for today. So by the end of this session, we'll be able to apply core ethical principles to decision-making in crisis care. We'll understand how to protect individual autonomy and recovery by prioritizing trauma-informed approaches to crisis care. And we'll be able to describe the challenges and potential ethical implications of crisis response in rural areas. Next slide, please. So as Jill mentioned, ethics is really foundational to the national guidelines. So we see this in our first pillar, someone to contact, with the idea of balancing contact autonomy with duty to report imminent risk concerns. In our second pillar, someone to respond, we have the on-the-scene decisions that we make around involuntary transportation, how to escalate a situation, maybe get emergency services involved. And then finally, in our third pillar, a safe place for help, we have the ethics of admitting individuals involuntarily or denying access based on capacity. Next slide. So we have a quick poll to kind of gauge what's happening with our audience. So we'd like to know, when it comes to ethical decision-making in crisis response, what feels most challenging for you? We have some options for you to pick from, so I'll give everyone just a minute to fill that out. What ethical decision-making is most challenging for you? It is single choice, and I'm sure some of you want to choose a multiple one, so go with the one that might be most challenging. Give just another second for those who want to participate to fill this out. I see in the chat, someone said navigating conflicting policies. Absolutely. Yeah, I'm sure if we left one for you to fill in the blank, we'd have lots of additional responses. Let's go ahead and close that poll. All right. So we had a pretty good mix between balancing client autonomy with safety concerns and navigating unclear conflicting policies. Matches what we're seeing in the chat. We're going to talk about those today. So hopefully you'll have some strategies and skills by the end of this session. Why don't we go to the next slide? So from the US Supreme Court, we have Justice Potter Stewart's quote, "Ethics is knowing the difference between what the right thing to do and," I can't read this doesn't make sense to me. "Ethics is knowing the difference between what you have the right to do and what is right to do." There we go. Words are challenging. Next slide. So we probably don't have to explain to you why ethics matter in crisis response, but just to be sure, we'll go over this briefly. So crisis situations can be time sensitive, right? They compress time, we have heightened emotions, there might be amplified power dynamics. So ethical clarity can be harder, but also more essential in those situations. The decisions we make carry weight. They matter for those that we're supporting and for ourselves. Ethics isn't just about avoiding harm. It's actively honoring the dignity and humanity of every person. That idea of autonomy and being able to respect the individual context that everyone comes from. So today's session is going to be a space for honest reflection. It's not a checklist of the right answers. It's not trying to identify what we've done wrong or right. It's trying to give us those skills and strategies to reflect on how we make ethical decisions in this crisis space. Next slide, please. Our guest speaker today is Dr. Frederick Reamer. And Dr. Frederick Reamer is a professor emeritus in the School of Social Work at the Rhode Island College, where he served on that faculty for 4 decades. He is a nationally recognized authority on social work ethics. His career is focused on reforming education and practice through extensive research, teaching, and scholarships, including dozens of books, almost 200 journal articles. That's a lot. Dr. Rimers chaired the task force that authored the National Association of Social Workers Code of Ethics, and he currently chairs their Technology Standards Task Force. Thank you so much for joining us today, Dr. Reamer.
My pleasure, Megan, and greetings to all of you. Good afternoon, good morning, depending upon the time zone you're in. I know it's customary to start these things off by saying, oh, what a delight it is to be here or there, wherever you happen to be. And I really am delighted to be here to talk about this really, really important topic. For me, this is not just an intellectual exercise. This is not intellectual gymnastics. This is really complicated stuff. And I spend a great deal of my time consulting on complex ethics matters. And I spend an awful lot of my time raising this hand. It has to be the right hand in a court of law or in a licensing board hearing for fascinating historical reasons. Going back to Roman times, it's only the right hand that counts when you're sworn in as what the courts call, what lawyers call an expert witness. And I get sworn in as an expert witness multiple times per year in two kinds of matters, many of them related to crisis work and challenges to the decisions that practitioners have made, where some disgruntled party is not happy with the decisions that a practitioner allegedly made. And sometimes they file lawsuits, sometimes they file licensing board complaints. I imagine some of you, not all of you, are licensed practitioners. And I bring that experience to my comments today. But I also want to add one other thing. Outside of my academic work, I have spent 27 years of my career working in federal and state prisons. I became a social worker decades ago, primarily because of my keen interest in criminal justice, criminology, and prison-related work. And as you might imagine, working in prisons, one encounters lots and lots of people who have experienced crises in their lives, some of which did not work out so well and they ended up in prison. Some of them experience crises while they're in prison. Some of them experience crises once they are released from prison. I spent 24 years of my career on a state parole board deciding who stays in prison, who gets out of prison, and lots of conversations about crises. So I'm bringing today my experience with that client population and their trauma, their crisis experience, and my role as an ethicist and my role as an expert witness in lots of litigation cases and licensing board cases. As Megan said, I chaired, and it was a great privilege to have chaired, the national task force that wrote the Code of Ethics for the social work profession. So just to reiterate a little bit, during the relatively brief time I have with you today, and for me, this is more like an hors d'oeuvre than the entree because we don't have a whole lot of time. In fact, it's more like the bite of an hors d'oeuvre. 6 things I want to do. I want to talk about ethical challenges and risks in behavioral crisis response. And I highlight that word challenges. I'm not going to spend time on the easy stuff. And I can give speeches about why it's a bad idea to have a sexual relationship with a client who's in crisis, why it's a bad idea to falsify clinical records. I've testified in those cases too many times, but we don't need to spend time on those issues because those are not real challenges. They're problems, not challenges. Number 2, I want to talk about risk management tips, what I've learned over the decades in an effort to protect clients and to protect ourselves, to try to minimize the risk of licensing board complaints, lawsuits, and so forth. Number 3, I want to say a little bit about technology because we know that technology has changed the face of crisis intervention work, behavioral health care more broadly. Many of us, myself included, started our careers at a time when the cloud was simply the white fluffy thing in the sky, full stop. Not where some of you are storing your electronic health and medical records. And some of those records are being created by artificial intelligence. That was not possible when I started my career, and I suspect that's true for many of you. When many of you started your careers, myself included, TikTok was the sound a clock made on the wall. That was it, not a smartphone app. which has created some problems, ethics-related problems for practitioners who post things on TikTok. When many of you started your careers, myself included, a tweet was the sound a bird made, full stop, not something associated with what used to be called Twitter, now called X. And that's become an issue in some licensing board cases. When I started my career, and I suspect this is true for many of you, it would not have been possible to provide crisis services to people living in another jurisdiction, another state, using your smartphone, your laptop, your tablet, whatever. Well, now, of course, that's a possibility, and it's raised all kinds of ethical issues having to do with the delivery of services across jurisdictional lines by people who may be licensed in the state where they're located, but not in the state where the client is located. This has become a problem. Number 4, I want to say a little bit about ethical decision making. So I'm all about focusing on the gray area cases, not the black and the white, but the gray area cases where you put several hundred people who specialize in crisis related services in a room, physical or Zoom room, and you present scenarios and they disagree about how to best handle those ethics related cases to protect clients, but also to protect themselves. Not only gray area scenarios, but gray area scenarios that have multiple shades of gray. That's where I think we need to think about how to make these decisions in a way that recognizes that there's an issue, analyze what's going on, try to resolve them as best we can, try to prevent problems. Number 5, I want to say just a little bit about documentation. Now, let's be frank. If I were to survey a representative sample of people who provide crisis services, and if I were to ask them, what do you like about the work you do? What do you not like about the work you do? Rank order all of that. For most people, in my experience, documentation would be at the bottom of the list of fun things to do. It's tedious, it's time consuming, it can be repetitive. I get it. It is not fun for most of us. Here's the reality. As someone who has spent a great deal of his time serving as a so-called expert witness in litigation and licensing board cases involving people who provide crisis services who've been sued or had board complaints filed against them, almost always, and I'm not hyperbolizing, I'm not exaggerating, almost always the quality of the documentation determines the outcome of the case. The reality is lawyers now will subpoena those records, right? It's called a subpoena duces tecum, D-U-C-E-S, new word T-E-C-U-M, Latin, and they will cherry pick your notes, the words, the phrases, the sentences, the paragraphs. If it's defense counsel in a case where a client who received crisis services died by suicide and surviving family members have filed the lawsuit, and I've testified in a lot of those cases, the lawyers are going to subpoena those notes. And using very fancy software, they're going to project those words, phrases, sentences, paragraphs on the screen in the courtroom for the judge, the jury, witnesses to see. And if it's defense counsel that's projecting those words, phrases, sentences, paragraphs, that's usually good news because it means the documentation about the risk assessment, about the treatment plan, the safety planning. P.S. I would never use the phrase contracting for safety. If you want, I can talk about that in the Q&A. I think that's a terrible mistake to make these days, to use the phrase contracting for safety. People used to use that phrase, not anymore. We don't teach it. If it's defense counsel displaying that documentation, that's usually good news. It means the documentation was carefully written, it was proofread, edited, entered into the record in a timely fashion. But if it's opposing counsel, every litigation case has lawyers on the other side of the case. We call them opposing counsel. If they project your words, your phrases, your sentences, your paragraphs from your treatment plans, your risk assessments, your summaries of clinical encounters, if they're projecting that stuff on the screen, it's almost always bad, bad news because they have found problems. They have found errors. They have found what they call omissions. They have found late entries. They have found what we call false narratives if the notes were generated by artificial intelligence. And it's usually bad news. And that documentation can sink the ship. And I see it repeatedly. And the final thing I want to talk about before we wrap this up, standards of care. So those three words, standards of care, have been the doctrine in US law since the late 1800s. That is when, in a very famous case called Coombs versus Bede, which originated in Lewiston, Maine, that is when the language of standard of care was introduced into the lexicon of US law. And here's the reality. Again, no hyperbole here, no exaggeration. Every single litigation case, lawsuit, every single litigation case that I get pulled into, I review all the materials, that's my job, and lawyers set up an appointment, we meet, and almost always they ask the following question. So, Dr. Reamer, now that you've had an opportunity to review all of the records, what they call tangible things, and ESI, that stands for electronically stored information, ESI is now in the law. It's in the federal and state rules of civil procedure. Lawyers will subpoena every text message, every email message, every online post, every entry in an electronic record, in addition to any written records. And they will ask me, once I've reviewed all of that, in my opinion, did the crisis worker meet the standard of care related to crisis intervention services? And there are lots of criteria that I'll talk about before we end that go into the determination of what lawyers call the standard of care. Dr. Reamer, do you think the crisis worker met the standard of care or fell below the standard of care? And if my opinion, other experts' opinions, are that the crisis worker fell below the standard of care, what's defined as what a reasonable and prudent practitioner with the same or similar training should have done in that crisis situation. Let me repeat. What a reasonable and prudent, meaning careful, cautious, crisis worker should have done in that particular situation, given their level of training and education, that's a problem. If the evidence shows that the worker's assessment, intervention, planning fell below the standard of care, because that's what a jury and a judge ultimately care about. I should add, I recognize that today we likely have people with different degrees of education. Some of you may have associate's degrees, some of you have bachelor's, master's degrees, some of you are licensed, some of you are not licensed. So this is probably a very mixed group. Some of you are probably providing peer support services, which I value tremendously. The standard of care is an elastic concept that takes into consideration the level of education, background, training, and so forth. Now, we started, Megan did, with some disclaimers. Here's mine. I work with a lot of lawyers. Here's my disclaimer. Today, my comments will include several references to relevant laws, some statutes, some regulations, case law, and some legal concepts. I just did that. I referred to the standard of care. I'm going to make some references to laws, such as at the federal level, HIPAA, 42 CFR Part 2, Title 34 CFR Part 99, otherwise known as FERPA. And then there's relevant state law governing some of the issues that I'm going to talk about today. That said, I am not an attorney. Nothing I say constitutes legal advice. You may decide at the end of our discussion today that it might be a good idea to consult with an attorney about some of your policies, your practices, your protocols. And I recommend finding an attorney licensed in your jurisdiction who specializes in behavioral health law, crisis intervention law, and who primarily defends, not sues, defends behavioral health and crisis workers in litigation and in licensing board cases. That's the kind of an attorney I want. In my experience, when I think about the consultation I've provided over the decades and the expert witness testimony I've provided over the decades, I would say there are 9 major themes that tend to pop up. There are some other issues, but I would say these are the big ones. Crisis workers who make sometimes very challenging decisions about the limits of clients' confidentiality, disclosures to protect third parties without client consent. Some of you know about the Tarasoff decision, which is often referred to as the red letter decision, regarding disclosure of confidential information without client consent to protect third parties from harm. Despite what some practitioners think, Tarasoff is not the law of the land. It was a major Supreme Court decision in California, but the California legislature has since revised its statute on so-called duty to warn, duty to protect, disclosure of confidential information. If clients are engaging in self-harm, they don't want their family members to know that they're engaging in suicidal thinking. How do you handle that one when you don't have their consent? You're subpoenaed. Many of our clients are involved in legal proceedings. You and your records may be subpoenaed, and you may have to make a decision about whether to disclose in response to a subpoena without your client's consent. Consent to treat. I mentioned that I am now spending a great deal of my time thinking about, writing about, lecturing about the use of artificial intelligence in crisis services. We know that a growing number of people are using AI to get help. They're using it at 2:37 a.m. when you're not available. They are using it when they don't have access to professional services. And I now recommend that every practitioner, every agency revise its consent to treat protocols to include language about the possibility that people who are in crisis or who may be in crisis will use artificial intelligence to get help so that we can talk about the potential benefits and the potential risks. And I think there are many. My most recent book is entirely on this subject of artificial intelligence in behavioral healthcare. And I think that warrants revisions to our standard consent to treat protocols. We need to bring it up, in my opinion. Informed consent issues related to that, circumstances where we do and do not need client consent to disclose confidential information to third parties, situations where you're dealing with a 15-year-old or a 16-year-old who wants services to address a substance use disorder issue, and state laws vary tremendously with regard to whether you need to notify parents and legal guardians about the provision of substance use disorder services to minors. There is no one-stop shopping here. Section 2.14 of Title 42 CFR Code of Federal Regulations, Part 2, Section 2.14 addresses this issue explicitly, and it basically says check out your state law, and those state laws differ dramatically. And I see the lawsuits, I see the board complaints where allegedly the practitioner didn't handle that well, didn't consult the law, made their own decisions without the right kind of consultation. Conflicts of interest, situations involving dual relationships. These are linked. The one after that, boundary issues, dual relationships, conflicts of interest, where there's some kind of secondary relationship providing services, and they also worship at the same church or mosque or synagogue. They have a social relationship. They have an online relationship where there's an alleged conflict of interest, inappropriate boundary issue, dual relationship. Some of you likely work and live in relatively small rural communities where it's not a question of if you bump into a client in the community, in the supermarket, at a place of worship, at a party, wherever it is. It's not a question of if, it's probably a question of when. There's a great deal of scholarship, some of which I've written, along with others, around the management of boundaries, dual relationships. Clients ask you personal questions, right? How old are you? Where do you live? Do you have any kids? Are you in recovery? Whatever it is, decisions about self-disclosure, decisions about accepting gifts, decisions about accepting invitations to the baby naming, the graduation ceremony. All of these things can come up in litigation and licensing board cases. Termination of services and abandonment, right? When we're dealing with crises, sometimes things don't work out so well. People die, people injure themselves, they injure other people. It happens. It doesn't mean there was evidence of negligence. We can do everything right, and you can still have a bad outcome. I've seen that happen in lots of cases, but sometimes the lawsuit, the licensing board complaint, alleges abandonment, inappropriate termination of services, failure to get back to the client who was in crisis in a timely manner. Now using artificial intelligence, where the artificial intelligence platform designed for crisis services doesn't include what we call an escalation protocol, that's jargon, that tries to link the person who's in crisis, engaging in suicidal ideation, with a human being. We call that having a human being in the loop. Some of these AI platforms do it and some do not. And I think that can rise to the level of abandonment. Abandonment is a legal term. Preventing suicide, harm to third parties. I know I'm speaking to the choir here, but I will tell you that a very significant percentage of the lawsuits that I get involved in, not so much licensing board cases, but the lawsuits that I get involved in involve allegations of negligence related to suicide, alleged failure to prevent a suicide. I'm involved in 4 of those cases right now, where people who were in crisis ended their lives, and disgruntled, upset family members have filed the lawsuit. And my job is to opine, as lawyers say, OPINE, about whether the crisis worker met the standard of care. Consultation, supervision, and referral. Just this morning, about an hour and a half ago, I was consulting with a lawyer in the Midwest and her client, who's a crisis worker. There's a licensing board case pending, and there's an allegation of a conflict of interest, inappropriate dual relationship. And I had to ask that crisis worker an hour and a half ago or so whether, when she made the decision about how to handle this dual relationship, which did emerge, whether she sought consultation. Did she seek supervision? And her answer was, no, I didn't. I thought I could handle it on my own. In retrospect, I now realize I probably should have sought consultation, supervision, maybe made a referral because of a conflict of interest. I asked her whether she was aware of a conflict at the time, whether she documented in her notes how she handled it and why she handled it the way that she did. Nope, not in the notes. Disaster, disaster. And that links to the final theme, which I've already mentioned: documentation, documentation, documentation. And now the growing number of crisis-related practitioners and services that rely on artificial intelligence, especially to generate summaries of clinical encounters. Let me give you a few hypotheticals, and these are based on real cases that I've been involved in as a formal consultant or expert witness in litigation and licensing board cases. So just to get you thinking, how confident are you that you have the knowledge and information you need to handle an individual's explicit request that you not disclose sensitive and important PHI, protected health information, about them to a behavioral health program to which you've referred them? So we know that people in crisis often need referrals. The client might not consent to the disclosure of details to the person to whom you referred them for treatment, or for their eating disorder, or their suicidal ideation, their depression, their bipolar symptoms, whatever they happen to be, substance use issues, right? I encounter practitioners who say, well, look, if my client didn't consent, I can't disclose details to the provider, even if I think they should know that. And I say, au contraire, HIPAA actually has a provision in it. HIPAA has a provision in it that does permit limited disclosure to other providers, even if the client doesn't consent to that disclosure, if that disclosure is for purposes of continuity of care, coordination of services, it's in the client's best interest. But as you saw in Justice Potter Stewart's quote that Megan shared earlier, just because you have the right to share that information under HIPAA does not mean it's the right thing to do, because it can rupture the clinical relationship. Very difficult decision. And when I apply my decision-making protocol before we wrap this up, this is an example of a case where I think reasonable minds can differ, and the process we follow, the protocols we follow to make these difficult decisions, when you could argue, respect the client's privacy, don't disclose to the other provider, even though HIPAA permits you to do that, or you might argue, need to know, that other provider does need to know this information, right? We might reach different conclusions, but the steps we take to make those decisions, in my experience, ultimately can determine whether there is a good outcome or a disaster. Next, to what extent do you feel confident that you know whether a program that provides substance use disorder services to adolescents who are in crisis is permitted without parental notification or consent. As I mentioned, Title 42 CFR, Code of Federal Regulations, Part 2, Section 2.14 has a provision in it that acknowledges this exact ethical dilemma, and it does not tell you what the answer is. There is no one-stop shopping. If you are working in Missouri, there's one answer based on Missouri law. The federal law refers you to the state law. If you're in Maryland, you got to look at Maryland's law. If you are in Michigan, you got to look at Michigan's law. If you're in Mississippi, you got to look at Mississippi's law. If you're in Montana, you got to look at Montana's law. And I could also name states that don't begin with the letter M. These state laws vary tremendously. And we have to know this stuff. What about situations when you do crisis work where the police show up? Now, Megan didn't mention this. She probably didn't even know this. I, for years, have been the ethics instructor in the major police academy in Rhode Island, where I am. And I know that police and detectives often want information from crisis workers. What do you know? Substance use history, mental health history, whatever, whatever, whatever. And you may not have the client's consent to disclose. Some of you have heard the phrase, "I can neither confirm nor deny." Well, HIPAA does actually permit limited disclosure of otherwise confidential information to detectives, to law enforcement officials who are investigating a crime where there's a fugitive, a material witness, a suspect. HIPAA actually permits the disclosure. That surprises a lot of people. But if you're doing crisis work in a substance use disorder treatment program where there is some form of federal funding and it falls under Title 42 CFR Part 2, what I consider to be the strictest confidentiality law in the United States of America in behavioral health, much stricter than HIPAA. In Section 2.63 of that very strict law, it basically says if a detective shows up and they're investigating an extremely serious crime, doesn't say serious crime, says extremely serious crime, murder, rape, robbery, that kind of thing, you are not allowed to even acknowledge that you know who the client is. HIPAA permits you to do that. HIPAA permits disclosure of limited information, but 42 CFR Part 2 does not. You actually need a judge's authorization to disclose. And this was designed to try to provide an incentive to people in crisis who are struggling with substances to get help. So I get involved in lawsuits where a disgruntled party says, you weren't supposed to tell the detectives anything about me because your job falls under 42 CFR Part 2, not just HIPAA. You were supposed to get a judge's authorization and that kind of thing. What about subpoenas? I mentioned earlier, subpoena ducis tecum, right? Subpoenas, they don't say, if you're in the mood, you happen to be in the neighborhood, please stop by. They command you, COMMAND, to appear, to bring your records, documents, tangible things, electronically stored information records, all that. I get involved in cases where practitioners did not know that they were supposed to challenge the subpoena, even though the subpoena commands them to produce this information in child custody disputes, in criminal court proceedings, divorces that our crisis clients are involved in. If you don't have the client's consent, you have got to challenge the subpoena, what lawyers call a motion to quash, not squash, that's a vegetable, motion to quash, or what they call a motion for a protective order. We're supposed to know how to protect clients' confidentiality as best we can. I mentioned the issue about practitioners who are licensed in one state, but the client is traveling, staying with a cousin because there's a domestic violence situation, but the cousin lives in a neighboring state where the practitioner is not licensed and they're providing services remotely, and that's turning into a problem, this interjurisdictional provision of services. I imagine many of you have had clients who have disclosed, air quotes, confidentially, that they have committed some crimes in the past. They've experienced trauma. They trust you. They share with you information about this traumatic past event involving, in one actual case in which I consulted, a client who committed a murder 7 years ago. was never charged, never arrested, never tried, never convicted, never sentenced, literally got away with murder. And the crisis worker had to make a decision about whether to consider this information confidential, this cold case, and also what to put in her notes. What do you put in the notes? Client disclosed that he committed a murder 7 years ago. I would not put that in the notes because there's no such thing as a confidential case record. There is no such thing. I can list 24 different ways in which records are not confidential, lots of exceptions. And if I put in there that the client disclosed he committed a murder, that could be used against the client. I'm not minimizing the seriousness of a murder. Of course not. I take that very seriously. But we have a duty to follow ethics standards regarding confidentiality, documentation. My notes would say client disclosed details about a past traumatic event. We talked about ways to cope. The client shared feelings of guilt, remorse. You have to know how to document, when to be vague, and when not to be vague. If the client says, I feel so guilty about this, I'm not sure I should wake up tomorrow. Oh, suicidal thinking. My opinion, you can be vague about the murder, but you can't be vague about the suicidal ideation. Some of you have probably included collaterals in sessions with clients. The spouse, the partner, the acquaintance, the cousin, the whatever, and sometimes collaterals share very sensitive information about their lives related to the client's life. And some of those details end up in records, in documentation. Those records can be subpoenaed. I was an expert witness in a major case where the crisis worker never said a word to the collateral about how confidentiality works. The collateral is not a client. Crisis worker cannot necessarily protect information shared by the collateral. My advice is have what we call a collateral agreement, either a piece of paper or it comes out of your mouth explaining what the role of a collateral is. They should understand that information they share may not be protected. And they should go into these conversations with their eyes open. And then I mentioned AI, how artificial intelligence is now featured prominently in crisis work in ways until about, I would say 2-3 years ago, I didn't see, but I'm seeing it now. I get involved in a lot of lawsuits, a lot of board complaints. And here's the good news. The overwhelming majority of crisis workers will retire without ever being sued, without ever being named in a board complaint. So the vertical axis in this matrix, the probability of a lawsuit, the probability of a licensing board complaint for those of you who are licensed, it's pretty low. That's great news. But then there's the horizontal axis. And as someone who does get involved as a so-called expert witness in lots of litigation and lots of licensing board cases involving people who provide crisis services, they are miserable experiences. These things last for many months, sometimes years, hanging over your head. It is horrible, horrible. So what I'm focusing on today is the lower right-hand quadrant. Low probability of a big problem, great. But if it happens, ever seen that bumper sticker that says one nuclear bomb can ruin your entire morning? All you need is one, and it's pretty miserable. So I'm going to squeeze a lot into the next handful of minutes. In my opinion, to protect clients, to protect ourselves, we should have a good grasp of three things: core knowledge. What are the kinds of ethical dilemmas? And I shared some examples with you, not exhaustive, but examples, where we have to make difficult choices, not the easy stuff. How do we make decisions when these challenges arise? I think that's where the action is. And third, what I call ethics risk management, doing this in a way that protects clients first and foremost, and also protects us as best we can. And in my experience, there are three major patterns. So I've collected lots of data on lawsuits, lots of data on board complaints, lots of data on ethical dilemmas, and I would say there are three patterns. Ethical mistakes. Oh, I didn't realize my job falls under 42 CFR Part 2. I should not have shared any information with a detective who has questions about my client. I thought I fell under HIPAA. Oops, that was a mistake. I consulted with my colleague on this difficult case involving confidentiality exceptions. I didn't document the consultation. It's not in my notes. And lawyers are fond of saying if it's not written, it did not happen. Oh, I met with the client's collateral, the spouse, the partner, the cousin, the acquaintance. But I never talked about the collateral's confidentiality and how I cannot necessarily protect it. That was a mistake. The second time, in some of these cases, we have to make very difficult decisions. These are not mistakes, these are tough decisions about confidentiality exceptions, when to be vague in case notes, when not to be vague. Those of you who live and work in relatively small rural communities, how to manage boundary issues and dual relationships, and on and on and on and on and on. And then finally, sadly, I get involved in too many cases, small percentage, but too many, where there's evidence of ethical misconduct, getting involved with a crisis client sexually, falsifying case notes, that kind of stuff, fraudulent billing. I've had all these cases. I mentioned standard of care. It is the key concept. Again, it originates in the late 1800s. That case that I referred to earlier, Coombs versus Bede, originating in Lewiston, Maine, that ends up going to the Supreme Court. It had nothing to do with crisis services, nothing to do with behavioral health. In fact, it had to do with a dispute between an architect and the architect's client. I don't have time to explain this whole case, but I would argue that today, the court's opinion in Coombs versus Bede regarding standard of care has everything to do with the issues I'm raising today. That in any instance where complicated ethical issues arise along those lines that I've mentioned today, we are held to this measuring rod. What a reasonable and prudent meaning careful, cautious practitioner with the same or similar training. Do you have an associate's degree? Do you have a bachelor's degree? Do you have a master's degree? Are you a peer support professional? What are you? What should you have done in those circumstances? But I'm especially concerned about the ethically complex cases, not the easy stuff. Like everybody agrees, don't have sex with the client. Some people don't adhere to that. Most people do. I'm talking about the ethically complex cases when reasonable and prudent practitioners don't agree. So we have hundreds and hundreds of people here today in this Zoom session. I would bet a year's salary that on some of those scenarios that I presented to you, you folks would disagree about the best way to handle them. That's where I think the action is in ethically complex cases. So what do you do if there's no clear substantive standard of care, if there are reasonable differences of opinion? And I'm about to summarize key points, and then we'll open it up for Q&A in just a couple of minutes. I argue that if there's no crystal clear substantive standard of care, and there is on some issues, don't falsify case notes, don't bill for services you never provided, that's called fraud, don't have sex with the client. Those are easy cases where we know what the substantive standard of care is, what a reasonable and prudent practitioner should have done. I'm especially concerned about the ethically complex cases. So to summarize, I think there are 10 things that we can do as crisis professionals to protect clients and protect ourselves. If it's a complex case, get consultation from colleagues, that's horizontal, or supervisors, that's vertical, and document those conversations. So you don't have some lawyer saying, you didn't document it, it didn't happen. Number two, some of you, perhaps not all of you, are held to professional codes of ethics in mental health counseling, in social work, in the addictions world, whatever. As I mentioned, as Megan mentioned, I chaired the national task force that wrote the code of ethics for the social work profession. Those codes of ethics evolve, they change, and they are part of the standard of care. They are often introduced as evidence in litigation cases. I'll be quick here. Number three, what we call national practice standards. Megan mentioned that I chaired another task force that generated state-of-the-art ethics-informed standards for the use of technology. Number four, relevant laws. Do I think all ethical challenges require consultation of law? No. The client asks you, how old are you? Where do you live? Are you in recovery? There's no law that tells you how to handle that. If a client gives you a thank you gift, I so appreciate what you've done for me. There's no law that tells you what to do. But on so many of the issues I've raised today, there are federal and state laws. I've listed a bunch of them there that are relevant to the ethical decision about informed consent, about confidentiality exceptions, conflicts of interest, and so forth. Many of you, most of you, I suspect, work in agencies. Number 5, agencies typically have policies related to a lot of these ethical issues. Those policies get introduced as evidence in litigation and licensing board cases. It's part of the standard of care. Relevant literature. Lawyers love to look for reputable, peer-reviewed literature relevant to the case. If they find reputable literature that supports their theory, they will introduce it as evidence. I see it over and over again. Number 7, knowing when to get legal consultation, not always necessary, but sometimes it is. For example, if you agree with me that you should be revising your consent decree protocols to incorporate language around clients' possible use of AI to get crisis services, you may want to run that by a lawyer licensed in your jurisdiction to be sure the wording aligns with the law in your state. Number 8, some of you might have access to ethics committees for consultation in difficult cases. Some of you, especially those of you who are licensed, probably have malpractice insurance. If you're licensed and you work for a crisis agency, I beg of you to get your own malpractice insurance. Do not, in my opinion, rely on your employer's policy. There can be a conflict of interest. Your employer's policy may not have enough money in it to cover the case involving suicide or homicide. If you have malpractice insurance and you smell an ethics-related problem, you may want to notify your malpractice insured. They can often provide consultation. And I just want to repeat one more time the critically important role of good documentation. I've got some other slides here. Don't have time to get into them in detail. For those of you who want more information about these topics, or you're struggling with insomnia, you need something to read to put you to sleep, the last slide here has a bunch of stuff that I've written that I'm drawing on today. So I'll have a final comment toward the end, but I will stop here and open it up.